So the worst possible thing has happened. The court has passed an order injuncting the usage of your trademark. What I mean is that someone filed a case against you for trademark infringement, right? Seeking an injunction against you on the basis that the mark that you are using is identical or deceptively similar to their mark. And the court, after hearing them, has passed an injunction restraining you from using your trademark for your business on the basis that they have a prima facie case, right? That their case on the face of it appears to be genuine, and then you are thus injuncted or basically stayed, temporarily restrained from using your trademark till the time that that case is being heard by the court, right? So now what will you do? You will quietly submit, bow your head and surrender and say that okay, you can stop me from using my trademark, I'll never use it again, right? Of course not. What you can do is you can appeal this order, and in order to appeal this, there is a certain process that you have to follow, which I'm going to tell you about today in this video. And that process is provided for in Order 39, Rule 4 of the Code of Civil Procedure, right? So let me go into detail about this today and tell you that what you can do to appeal such an order, right? And what your lawyer, if you choose the right lawyer, is basically going to do or going to have to do to get you out of this kind of a mess in a trademark infringement suit. So the injunction order that I'm talking about here is an ad interim injunction, right? It is a temporary restraining order that is passed at the initial stages of the case, right? And like explained, that it's on the basis of a prima facie case. So if the court feels that there is a prima facie case, then only they'll restrain you from using that particular mark. And if at this point of time you don't take the right steps, you don't take the right course of action, or your lawyer doesn't take the right steps, then you could be restrained from using your trademark for at least a couple of years till the time the case is going on, and maybe even permanently if the case is wholly decided against you. And this chance of permanent injunction is all the more likely if you don't appeal that interim stay at the right stage under an application in Order 39 Rule 4 of the CPC, right? So what are these correct steps, right? This is what I need to guide you on today. And what are the grounds that this application under Order 39 Rule 4 should contain for the court to pass an order in your favor to vacate or basically take away that injunction order that has been passed against your trademark and in favor of the plaintiff, right? So let me first tell you what is a plaintiff and what is a defendant. The plaintiff is the party that files the case against you, and in this case, if you are the defendant, you would be defending your case, you would be defending the usage of your trademark. So now let me get, without any further delay, to the actual grounds that you need to plead in your Order 39 Rule 4 application. So let me discuss the very first ground, right? If the injunction order was passed ex parte, meaning that it was passed in your absence without giving you notice, then you should show the court that the party which has filed the case, right, the plaintiff, has concealed material facts and documents at the time of filing the suit, which they didn't disclose even when they got the injunction. And this is very important, because if they have hidden something from the court, then this could have swayed the court in their favor and against you, right? And this is the reason that maybe they got the injunction. So if you're able to show the court that this party, the plaintiff which has filed the case, is actually dishonest and they concealed material facts from the court record, they didn't file all the documents along with their suit that they're supposed to, then also you can, in your application under Order 39 Rule 4, get that injunction order vacated, right? So now, what kind of things can you plead, right? What could they have possibly hidden from the court? So maybe something like, that your actual year when you started the business, something like that, like they haven't told the court that when you actually started this business, or when something like a cease and desist notice which they sent to you and you gave a reply to that cease and desist notice, they concealed from the court. So in that kind of a scenario, you can say that they have been dishonest and they have concealed material facts from the court, and you can even have this injunction order possibly vacated if you argue it well by the court. And this application under Order 39 Rule 4, always remember, is filed before the court that had given the injunction, right? It's not filed before the division bench, it's not filed as an appeal under Order 40 Rule 3 of the CPC, it's filed as an application under Order 39 Rule 4 of the CPC before the very court that gave that injunction order. So the same judge will be hearing it, but you will be putting forth important grounds on the basis of which you can argue that that application should be allowed and that injunction order should be vacated, right? Secondly, you have to argue that unfair hardship was caused to you and your business, right, because of the injunction order. So you will have to demonstrate to the court that as a result of that injunction order being passed, your business has suddenly come to a standstill, right? And for this, it would really help if you are able to show the court that I've been using the trademark for business for several years, right? You would have to argue that all your merchandise bears this trademark, that your official tax returns, your filings have been done under this trademark. So in essence, overnight you cannot be stopped or in the course of a few weeks from using the trademark, and the court shouldn't pass this order in such a hurry without hearing it completely, and they should take your unique circumstances into account. And in fact, it's not even necessary that it has to be several years, even if it's been a considerable period of time that you've been using this trademark. So at least you can convince the court that you should be given more time, right? And you should be completely heard before such an injunction order staying the usage of your mark is passed against you, right? It would also really help your case if we can show the court that the plaintiff has filed the case after a lot of delay, right? Especially if they have known about your trademark for all this time, all these years, and they chose to stay silent and only filed the case against you when they started seeing you as competition for their business, right? Which is just very unfair, right? And another major defense is that of acquiescence. Now, this is something that I've discussed in one of my previous episodes as well. Acquiescence is when the plaintiff has somehow impliedly or actively consented to your usage of the trademark, which they are now suing you for, right? So quite obviously, if they themselves have consented to the usage of your trademark, then they cannot now stop you from using it, right? So this is one very important ground. And then of course there are the general defenses that we invoke in IP cases, such as the trademark of the plaintiff being common in the market, or it being descriptive in nature, or the trademark having lost its distinctiveness, the trademark being a surname, all of those kind of things. Now always remember that for an injunction, for having this injunction vacated, it's always best to go for an application under Order 39 Rule 4 first, rather than appeal straight away under Order 40 Rule 3 of the CPC, or Order 40 of the CPC 43. Because if your main grounds are those that I explained in this episode, then there is no reason to go under Order 43 appeal. You should go under the application under Order 39 Rule 4, because you have valid grounds for the injunction to be vacated by the very court that had granted it. And so even if you do go and appeal, you may be sent back. So I'll give you an example actually of how this works. So there was one case in which I was one of the counsels representing a very prominent ice cream brand, and I'll give you a little bit of a hint. It's an ice cream brand which makes its ice cream from very, very natural flavors, and in this case, when the case was heard, so the injunction was passed in favor of our client, in favor of the prominent ice cream brand, and the party that we had gotten the injunction against went straight away to an appeal before the division bench, and they argued that this injunction was wrongly granted, this and that, and the court basically sent them back to the appeal court. The one of the two judges sent them back to the same court which had granted the injunction and said that you file an application under Order 39 Rule 4 over there first before coming to us in appeal, and that is where you can argue for getting this injunction order vacated. And so then they went into that application process. So it was an unnecessary waste of time and money for them to first go in the appeal before the division bench, right? So always remember, this is a very important ground. Even though there are divergent judgments on this, courts have held that you have the right to go both straight away in appeal to the division bench, or to go in under an application Order 39 Rule 4, and there's no hard and fast about it. But in practice, it may very well happen that if you have the ground for an Order 39 Rule 4, and if you haven't first went under an Order 39 Rule 4 before the same court that granted the injunction, and straight away went to appeal before division bench, then the division bench, the bench of the two judges may just send you back to the court that had granted that injunction and tell you to file an application under Order 39 Rule 4 over there first. So always remember this. And that was it for today. Do subscribe to my channel if you like the content and find it useful. Keep coming back to learn more about IP law, tech law, commercial law, and how you can protect your brand. Thank you.